Pronouncement of judgment, review petition 27/2022.
The review petition is dismissed. The interim order is recalled.
Item 2 for hearing PIL Sumoto 1/2020.
I just want to mention one point to your lordships that I have contracted COVID, tested positive. My daughter has also tested positive. We are high-risk patients, so I could not come. I find it difficult to sit also. I don't want that any proceeding should be stopped. I'm only saying this. I should recover in at least 5-6 days or a week. Give me a small chance for 10 or 20 minutes. I'm totally helpless, my lord. I was waiting till the end. I had a doubt when I was coming. Yesterday evening, the result came, and I was told it's a high degree. So both of us have got it, my lord. Only an accommodation for me. So I would never ask. I've been appearing on all dates. Whichever date you give me 20 minutes.
Okay.
We try and follow this. I'm lying down.
Okay. Okay.
I'm
Okay.
grateful now. Very grateful now.
Mr.
Very,
Mr. Kohli,
very.
My lord,
we'll have to adjourn it today.
I'm in my lord's hands. my lord.
Because when the AG is unwell.
Yes. No, I fully understand that. No, I fully understand that.
And they are both, he and Ms. Nitya are both in isolation. So I think we'll adjourn the matter.
No, I'm in my lord's hands. No.
Mr. C.T. Jamil, learned senior counsel along with Mr. Vati Jamil, is learned instructing counsel, as well as Mr. A. Ponganar, learned standing counsel for the High Court, are present through video conferencing. Mr. A. Dasgupta, learned senior counsel, along with Mr. S. Datta, learned senior counsel, along with Ms. Mushari, you are there, along with Ms. Mushari, learned instructing counsel are physically present. Sir, along with the Advocate General, please record the presence of Mr. K. Kalita. Learned counsel for the for respondent number 8 is also present. Next para.
Lordship, I'm also present.
Nitya is also present.
Yes.
He is also present.
I'm also present, Your Lordship.
He and yes.
Yes, yes. I can't. Who had addressed us, Ms. Nitya? You were addressing us?
Yes, Your Lordship. I said I'm also
Yes, we'll record your presence.
Your Lordship.
Let me record. Let me forward the list of lawyers.
Mr. K.N. Balgopal, Advocate General for the State of Nagaland. instructed by Ms. N. Nambiar, learned counsel, appears through video conferencing and submits that he is suffering from COVID pandemic and therefore are in isolation, and therefore he prays for adjournment. So he's also assisted by Ms. T. Kroll, an additional advocate general for the state. Next, considering the medical condition of the learned advocate general on the matter stands adjourned today. List. Mr. Bhagopal, when should we? I'm sorry, I forgot Mr. Kohli. Mr. Kohli, learned senior counsel. It's video conferencing along with Mr. K.
Along with Siddharth Barua, Mulod, my instructing counsel. Mulod.
Along with Mr. Siddharth. Is also this video conferencing. Please suggest a date. Please suggest a date, all of you.
Okay. 20th or something, if it is okay with me, I know, of course. Any date your lordship, please, just.
After 10 days?
Very good, man. Very good.
No, after 10 days, I'll be in some difficulty, Mulod.
Just suggest a date, because otherwise.
Somewhere in those,
either you participate or we become at what do you call what is it called? Dictator.
Because I was going to request if it could be somewhere in the end of June, Mulod.
No, okay, no difficulty with that.
Mulod, if it's convenient to the others, Mulod. If it could be 27th, Mulod, that'd be very great.
27th. 27th is a Friday, it's a motion day. Either 24th or either 24th or
24th will be
24th. Mr. Datta agrees to 24th.
24th, I'll be in travel. Mulod, I actually won't be able to join at all. If Mulod could have it, then Mulod, anytime on the first, second, third, whatever day suits my lords, Mulod.
Because that will be too long. We are not sure about our roster.
We are on holiday on that.
Mulod, actually, my lords had indicated last time that I will get only half an hour more.
No,
Just
and
to cover the 2 points which my lords had indicated. And Mulod, therefore,
can we have it on 19th? Can we have it on 19th?
On the 19th.
Very well.
Okay.
Actually,
19th will suit us, Lordship.
I'm so sorry, Mulod, but June is actually the time when the Delhi High Court is off. So I will be traveling on vacation during that time, Mulod, from 10th to 25th. So any time after that, Mulod, which is why I requested the first day I'm in office is 27th. I was only requesting, Mulod, I'll take only half an hour. So if Mulod would permit me, I'll finish in half an hour's time. And Mulod, it's a Friday, we could finish it, Mulod. It'll be within this month also. Subject to my lord's convenience, Mulod.
26. What about 26th then?
26, I'll be.
Because you see, we have our difficulties because our vacation starts from last month on 28th. So we have a lot of pressure on us in the last week.
Vacation.
Week commencing from 23rd or a week before that.
Or
Starting from 16th.
or what we can do is because since we can't adjourn it for so long, what we do is that we will permit the Advocate General to switch off the video conferencing today. He may be there listening by an audio. Ms. Crow is also already here, physically present. He can hear Mr. Kohli and then give you a feedback.
Alternatively, if I could just suggest, not so late, if will have it on the 11th, we could finish it on the 11th, subject to.
Because today and 11th is same thing for Mr. Bhargopal. So might as well do it today and then since you will take only half an hour, so your part is over.
In which case, Manoj will permit me one little indulgence, Manoj. if Manoj will permit, Manoj, if my learned friends are all fine in the week of the 16th, then Manoj, if I could just check out my schedule, Manoj, on vacation, wherever I am fixed for one, I'll Manoj join from there and finish it, Manoj, in my half an hour, Manoj. So around 16th or 17th, if Manoj will grant me that indulgence, Manoj, in the next 15-20 minutes,
17th is okay. 17th is okay.
Milord, what I understand, the lordship idea is very legitimate in the sense, Mr. Kohli.
No, every idea by the court is always legitimate.
We always respect the decision of your lordship. The question is, Mr. Kohli is ready. Now he can argue, he will take just 30 minutes. And the learned additional advocate general is there, she can look it.
Yes, Mr. Kohli, you can do it today.
Manoj, I'll actually need to be present in any case on the next day, Manoj, because if there's anything which Manoj comes, I was under the impression, Manoj, that this is going to finish today. And that's how, Manoj, I had planned it, because my Lord had indicated that I'll be the last one to, Manoj, address the court, and then the matter goes for, Manoj, the judgment would be reserved, Manoj. But, Manoj, if the learned Advocate General is going to be addressing the court, Manoj, I'll have to be there in any case, Manoj.
No, he's not addressing the court.
No, Manoj, my learned friend did ask for, Manoj, 20 minutes, Manoj.
Okay.
17th. Manoj, I'll do it on the 17th, Manoj. I'll take half an hour on 17th. We'll finish it on 17th, Manoj, when everybody is there.
Sorry.
Okay, then 17th.
17th.
Public.
Your
Lordships, on the last day, my reply remains inconclusive and I
Yes.
will take a short time.
Yes, yes. We remember it.
Yeah.
So 17th, then
Lordship,
Correct.
Very great.
list on 17, 6, 2025.
Grateful, Manoj. Manoj, permission to join through VC, Manoj.
Okay, that you can always send the request. We
do, but
Huh.
Manoj, I'm just, Manoj.
Okay.
Grateful,
We
Manoj.
granted to the appearing council of Senior Council to address us on video conferencing on the next date of listing.
Grateful.
Item 12, pronouncement of judgment oblique order.
Petition is dismissed.
My lord, I'm seeking lordship's indulgence to move a petition, my lord, as an unlisted, my lord. The man has been arrested on 25th. Until now, he is untested. Police is also not saying where about person, my lord.
Please ensure that copies are given to the government advocates.
My lord, we have given, my lord, we have filed it, my lord, yesterday. So copies, served, my lord.
No. They may not be carrying the files today.
My lord, my
Being
lord.
listed.
Yes, ma'am. Yes, ma'am.
Ensure they
Yes,
have
ma'am.
copies. Okay.
No, with the consent of the
That's
petitioner.
true, my lord.
No, with the consent of the petitioner, my lord, which means item number 9, my lord. Need some accommodation because AG is he is out of station today, my lord.
Okay, adjournment slip was given
There is advance message given, my lord.
Okay. with consent of the other side. The Learned Training Council for the GMC and GMTA. Sorry, GDD and GMC have praised for adjournment. Prayer is allowed. List on
After vacation, my lord.
There will be after vacation, my lord. On any Tuesday, Thursday.
listing the week commencing Okay, based on 22/7/2025.
No, sir, 22.
Oh, that's.
May I pay for listing of a matter, 2020 matter? These matters will not come for these next 2 weeks. Because we are taking up APSC matters. Next week or? You make a mention after that because it's really not coming. We are hearing these APSC matters, for hearing other matters are not coming up. The hearing matter, my lord. You understand, but the bench is hearing a pattern matter. Yes. We can't really hear any other matter during this tenure. Make a mention after 2 weeks. After we are not, it will not be listed for next 2 weeks. No, another matter, my lord, that is for admission. New matter, my lord, 2025, my lord. Already record is received by this honorable court. Well, good luck.
May it pleases your lordship. Lordship, petitioner's son is being arrested on 26 and thereafter he doesn't know the whereabouts of two petition I have filed. Lordship, I may be allowed to move the petition at 2 o'clock, lordship.
Okay, but ensure copies to them.
Yes, yes. One already we have served it today.
The problem will be, my lord, we have to go through it. Can this matter be fixed tomorrow?
No, because once these whereabouts are not known, we will have to take it up.
If it can be taken tomorrow also, my lord,
No, but tomorrow is not very sure that you will be able to tell us where the man is.
because my lord, we don't have.
No, even a day counts
Yes,
in these matters.
Deep privilege.
then let them serve a copy now.
May I please address? May I please address? Should I make the mention for listing motion matter, new matter, matter? Motion matter, matter. Petition I have filed yesterday, day after tomorrow, matter.
May it please your lordship. I'm paying.
Not day after tomorrow. It will either come on Wednesday or Friday, not on hearing days. Give it to the court master, let them. Tomorrow if possible. Either tomorrow or Friday. Tomorrow. On Tuesdays or Thursdays, there no new matter will be listed. Tomorrow.
Lordship, I would like to mention item number 8. The learned counsel PTK has not well, can the matter be adjourned?
No, 8 we are not adjourning because on Tuesdays and Thursdays you'll have to give us advance memo, otherwise matters are not being adjourned.
Lordship, can the matter be fixed on next Tuesday?
No. Let it remain in the list because on Tuesdays and Thursdays you'll have to give us advance information. Otherwise, we are not adjourning any matter.
May it please your lordship. Which I'm paying for listing of this two matter, lordship. It was fixed for interim order, lordship. Consideration of interim order, lordship.
Due to the court master.
Item 13 for motion.
May it pleases your lordships. My lord, petitioner elder brother was arrested on 26th lordship at 2:30 AM.
Where is the opinion?
Opinion, the petitioner doesn't know when he was arrested. Thereafter only they came to know that and reference was made against them. They made an inquiry thereafter and applied. I made a statement, lordship. So it was an ex parte opinion, lordship. But the whereabouts, even they went on page 17, I have stated, lordship. Page 17, wherein they went to get the signature in the Wakalatnama. That was also not allowed. I have page 17, paragraph.
Where you have referred to the ex parte opinion?
Ex parte opinion I have referred in paragraph, lordship. There, paragraph 3, lordship. When he was arrested, thereafter he was brought. He was arrested from his permanent address, lordship. That I have stated also in paragraph 4. That means he has provided his permanent address to the referral authority. So notice could easily be served to his permanent address, lordship. That I have stated in page 8, lordship.
Mr. Pai, can you get us at least the copy of the opinion? And information as to whether they were arrested in connection with FT matters.
Yes, my lord, you can get the information, my lord, no issue. That, but to get the copy of the, my lord, this case, my lord, copy of the order, it will take 2 days time, my lord.
It's okay, we'll take it up on
Information I
Friday.
can get, no issue.
Friday we can take it. You can
Yes.
get scan copies.
Yes, yes.
It's FT4, Kamrup Rural, Metro only.
It's okay, but they'll have to write and then get it.
Yes,
There's
sir.
some process.
Yes.
Okay, then we take it up on Friday.
No issue.
And we have stated, we have applied for the certified copy of the entire case record, means and do a process server report, notice.
Okay. Okay. Heard Ms. D. Ghosh, Lieutenant Constable, Mrs. D. Ghosh, Lieutenant Constable for the petitioner. Also heard all the respondents there, Mr. Amar Adhikari, CC on behalf of respondent one.
Correspondent number 1.
Okay, you are there. Mr. M. Islam on behalf of Mr. A.I. Ali. Next, the London Council for the petitioner has submitted that on 26/5/2025 at about 2:30 a.m. the elder brother of the petitioner, namely, Wajuddin, Wajuddin, was detained, was arrested from his house at village Bheragaon, Bheragaon, under Borpeta police station. And thereafter his whereabouts is not known. First off, it is projected that after inquiry, the petitioner has come to learn that a case was registered against the said Wajuddin at Azra police station within bracket border. Sorry, border police under Azra police station, which was numbered as Azra ES case number 27 of 2015, which was referred to the Foreigners Tribunal, and accordingly FT case number 1435/2017 was registered before the learned member, Foreigners Tribunal number 4th, Kamrup Metro, Guwahati. Stop. It is further projected that the petitioner had applied for certified copy of the case records on 28/5/2025, which has not been furnished to him. Next paragraph. According to the learned additional senior government advocate, as well as the learned standing counsel for the FT matters, are requested to obtain information about the alleged arrest and detention of Wajuddin, the projected brother of the petitioner, and to procure a scanned copy of the opinion, comma, if any, rendered in the proceedings of FT case number 1435 of 2017 from the Foreigners Tribunal number 4, Counter Metro Guwahati. Next paragraph, list in the motion column on make it 6/6/2025.
Deeply blessed.
Daily list item 1 hearing.
Petitioner, all the respondents are represented. So if the petitioner defaults in appearance on the next date of listing, comma, adverse orders would follow. Next paragraph. List on 12/6/2025.
Item 2,
Same order here.
item 3,
The impound order at page 31. Farm vital information, Lordship, that was not disclosed in the written statement. Subsequently, that was disclosed in written evidence, Lordship. That was not considered, and as a result, Lordship, not a single Lordship exhibited documents have not been discussed, Lordship, in the impound order, Lordship. Your Lordship may see page 34 from starts from paragraph 8, Lordship.
Which page is your written statement?
Page 25.
And where is your evidence?
That is, we have not annexed, Lordship. Lordship, learned tribunal that is pointed out in para 8 of the impugned judgment, Lordship. Contradictory statement between, Lordship, written statement and in evidence, Lordship. This is mentioned in para 8 of the impugned evidence.
There's nothing here. Your evidence is not creditworthy. It doesn't, is not worth anything. The OCD says grandfather left 2 sons and 1 daughter. Their name is Sadhu Sheikh, Sobesh Ali, and Jorina Nessa. And your father says one son and daughter, late Kismat Ali and Morijan Nessa.
In written statement, Lordship, Utlu Buzrug Ali was referred as a grandfather of the petitioner. Actually, Utlu Buzrug Ali was the great grandfather and Kismat Ali is the grandfather, Lordship. That is clarified in evidence, Lordship. To arrive in a findings, Lordship, exhibits which are available on records that require to be discussed, Lordship. Here in
No
this-
point discussing. Exhibit A is the certified copy of NRC 1951. Exhibit B is certified copy of 1966. What is certified copy of 1966? We don't know. Exhibit C is the original linkage copy.
Lordship, petitioner's father name was reported in the NRC of 1951. In serial number 5, page 19, Sabun, Lordship, as mentioned as Sabun, who himself, Lordship, adduced evidence as a DW2 before the tribunal, claiming the petitioner is his daughter, Lordship. That was not discussed. Evidence of DW2, father of
He
the
says nothing. He says nothing. He merely says in two paragraphs. The first paragraph is, I am a citizen of India by birth, having permanent resident of above noted locality. Para 2 is, I am the father of opposite party. My name has been recorded in NRC of 1951, 85, 89, and 97, which is submitted with DW1.
Yes. He mentioned the petitioner is, he is the father of the
But
petitioner.
there is nothing in DW1. DW1, we told you that there are three exhibits. So he says nothing. For this, we can't remand the matter. This evidence, we will consider it here. It's not, it is worth nothing.
So my humble understanding, Lordship, the exhibited documents as well as the statement of any
It must be
party-
worth something.
Yes.
Evidence must be worth something. You tell us what is the worth of NRC 1951, and that too certified copy. Certified copy is issued by the police. Whether police is the authority which can give certified copy. And this document itself is not a certified copy, it's just a photocopy. Certified to be true copy. Certified of true copy and certified copy are two different things. This is worth nothing. '66. You read this, the difficulty is that you don't read the trial court record. Just ask somebody to be here. Just send this down. He is your father? First of all, what is the father name of the father of your father?
Kismat Ali. Kismat Ali.
Kismat Ali.
Yes, sir.
And then whose name appears in 1966 voter list?
Great grandfather.
Great grandfather.
Yes.
Now look at the evidence of DW1. Read the first line. I so and so.
I, Sabu Sheikh, son of Kismat Ali, grandfather of Kutu Buzuruk Ali,
Ah.
is it about so and so. While
So he is the grandfather of Kutu Budrik.
yes, Lordship. Kutu Buzuruk is the grandfather of Sabu Sheikh.
I don't know what is written is in English.
Yes, Lordship. Sabu Sheikh said, Lordship, this Kismat Ali is
We
his
don't,
father.
this is an
And
affidavit.
Yes, Lordship.
If you
And
can't
grandfather
understand an
not
affidavit,
Putu
if you can't understand an affidavit,
Yes, Lordship, not properly written, Lordship, but
no, we
it
don't know.
means-
Nobody is accusing that the affidavit is not good written well. Who has made the allegation that the affidavit is not correctly written? No one. In a writ proceeding, how can I presume that the affidavit is wrongly written?
here mentioned, Lordship, I, Sabu Sheikh, son of late Kismat Ali, and grandfather name is Putu Buzurg Ali.
No, grandfather of so and so.
Yes, Lordship, grandfather, that
Then-
means, Lordship, grandfather name is Putu Buzurg Ali.
End of the matter. Why?
Okay.
We would not like to discuss.
Yes, Lordship. That is not properly written, but
No, nobody is accusing. We are repeating it for the second time. Nobody is accusing that the affidavit is not written well. Nobody doubts the ability of the learned lawyer. Then his first statement is that my name appears in NRC of so and so, which is available with DW1. DW1 did not exhibit NRC of 51. Second is 66. Voter is, and third is linkage certificate. Linkage certificate has state symbol. End of the matter.
Lordship, in prose also, Sabu Sheikh, it is clarified, Lordship. Putu Buzurg Ali was his grandfather, Lordship. In prose also it is mentioned.
That is contradiction.
Yes, Lordship. That is good. I am praying for Lordship. This matter will be remanded and asked, this
No, it's
executed
got some
documents
doubt.
may be discussed, Lordship,
You may.
as well as the evidence of DW2,
No, no,
who happens to be the father of the petitioner.
You see, we'll accept your prayer, but please convince us. Unless there's an essential pleading here, why would you discard an affidavit and then say that no, you need further evidence? It's not the case of the petitioner that she wants a fresh evidence to be or written statement to be filed.
Yeah.
If she does not want, can we impose those conditions to the petitioner?
So-
He will say that the order is not compliable. I never asked for it. Why should I need further evidence?
So far the evidence of DW2 is concerned, Lordship, it may be taken into consideration. It is duly disclosed that his father, he mentioned that his father is Kismat Sheikh, Kismat Ali, and grandfather Putu Buzurg Ali, and petitioner is his daughter, Lordship. DW evidence is clear, Lordship. So far, why I gone through the cross exam part is concerned.
Okay. Yes.
Lordship. Lordship, there is nothing, my lord, where Lordship, at first, Lordship, there is no link document. Lordship, no link document has been submitted, my lord. And there is no document to show that Purmoti's father is Sabu Sheikh or Sabu Sheikh's father is Putu Sheikh, Putu Buzurg Ali or Putu Sheikh. And Lordship, apart from that, Lordship, he is relying on Lordship NRC document where in WS he said that grandfather name is Putu Buzurg Ali, son of Bigot Ali, but in NRC document itself he relying on this document, although it is not admissible document, Lordship, and police authority has no authority to issue NRC document, Lordship. So Lordship, although he is relying this document, Lordship, here what discrepancy is found, Lordship, in WS he has stated that his grandfather is Putu Buzurg Ali, son of Bigot Ali, but here Lordship, Putu Sheikh, son of Binod Sheikh, page 18.
Yes.
Not Bigot Ali, Lordship. This is one discrepancy. And Lordship,
Oh.
A contradictory statement has been made in WS Lordship. Apart from that, Lordship. Already.
Eight of it,
And Lordship one aspect Lordship will see the voter list. Her name first time reflected in the voter list of 1997 at the age of 48 years. And prior to that, Lordship, no document has been submitted, Lordship. Page 14, Lordship. Vernacular is also there, Lordship, page 15.
No, her evidence is that I have voted in 1997 and in all elections thereafter.
Yes, Lordship.
And in 1997, I was declared as a D voter.
At the age of 48 years, Lord.
No, whatever be, but
Mm.
she says that she's been casting her vote after 1997 in all elections.
Mm.
And then she says in 1997, I was declared to be a D voter.
Yes, Lordship. And Lordship, in WS Lordship, he states that father's name is Sabu Sheikh and grandfather's name is Putu Bujurg Ali. But in 1989 voter list, Sabu Sheikh's father's name is shown as Kismot, Lordship. 1989 voter list, Lordship. It is
Page
Lordship 23. Translation is at page 22. Vernacular at in electoral roll. 1966 electoral roll call.
Mr. A.T. Sarkar, learned counsel for the petitioner. Also had Mr. M. Islam and for the CGC who was there, Mr. B. Sharma, Ms. B. Sharma. Okay. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 8/3/2016, page 31, passed by so and so in FT case number so and so, reference case number so and so, ERO case number so and so, 3 reference. By which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Do you say illegal migrant or post 1971 stream? Next paragraph. Assailing the opinion the learned counsel for the petitioner has submitted that the learned tribunal had failed to discuss the evidence of DW2 and that none of the documents which were exhibited along with the evidence of the petitioner as DW1 were not discussed. Full stop. Moreover, it is submitted that as the written statement as well as the evidence submitted by the DW1 and 2 lacked material particulars, the matter be remanded to the learned tribunal for a fresh opinion by allowing the petitioner to submit additional written statement and additional evidence. Next para. Pursuant to the order passed earlier, the records of the tribunal is received. The same is perused, and the submissions made by the learned counsel for all sides have also been considered. Next para. From the record, next para, from the record, it appears that the upon receipt of notice, the petitioner appeared before the learned tribunal and she has submitted her written statement on 20/10/2014. Wherein she had projected that she is the daughter of Shabu, Shabu, Shabu Sheikh, and that the allegation that she has entered into Assam from East Pakistan or Bangladesh between 1/1/1966 to 25/3/1971 is absolutely false and baseless. Petitioner has asserted that she is an Indian citizen by birth and her parents are also bona fide Indian citizens. She also projects that the name of her grandfather is Putu, Putu. Next word is Burjuk, Bujruk, Ali, son of Begot, Begot. Ali, Ali, was an Indian citizen and that her grandfather's name appeared in the voter list of 1966. At 7 number Kamnir Bhita, KAMNIRBHITA, village under PS Lokipur, LAKHIPUR, in the district of Goalpara. Under Number 44, West Gwalpara, LIC. Post op. Petitioner claims that the name of her father is recorded in the voter list of 1989 as Shabu, Shabu, Shabu Sheikh, Sheikh, son of Kismat, Kismot, Kismat Ali of village Banchadoba, which was under number 39, Jaleshwar, Jaleswar, Jaleshwar, LAC. And that she does not know why a D mark is made against her name. Next paragraph. It's on 18 to 2016, the petitioner had submitted her evidence on affidavit as DW1. As well as the evidence on affidavit by her projected father as DW2. Full stop. In her evidence, in her evidence, she claims that her father's name is Sabun, Sabun, Sabun alias Sabu, Sabu, Sabu Sheikh, Sheikh. Name of her mother is Rup Bhanu, RUP, next word, BHANU, alias Rup Bhanu, one word, RUP, BHANU, Bhanu Nessa, next word. And the name of her grandfather is Kismat, KISMOT Ali, alias Kismat, KESMOT, alias Kismat Ali, KESMOT ALI. The name of her grandmother is Bulujan, BULUJAN, Nessa. Name of her great grandfather is Putu, PUTU, Sheikh, SHEIKH, alias Putu Bujurik, BUJUREEK, Bujurik Ali, son of late Binod, BINOT, Binod Sheikh, SHEIKH, alias Bigot, BIGOD, alias Bigot Ali, BIGOD Ali. And the name of her great grandmother was Obiron, OBIRON, Nessa, and Kulshem Bibi, KULSHUM Bibi. And that her correct name is Fulmoti, FULMOTI, Nessa, NESSA. Full stop. She has further projected that the name of her father, grandfather, grandmother, great grandfather, and great grandmother was enrolled in the NRC of 1951. in village Mashaneralga under Bilasipara police station. And after the death of her grandparents, her great grandfather, along with her minor father, shifted from village Mashaneralga to village Kaminer, Kaminer Beta Bheta. Where a name of her grandparents was entered in the voter list of 1966. Most of the petitioners also stated that the name of her grandparents was enrolled in the voter list of 1977. And after the death of her grandparents, great grandparents, his parents shifted from village Kaminir, Kaminir, Kaminir Bheta, Bhita, to village Banchadoba, Banchadoba. And their names were entered in the voter list of 1985. And she was born and brought up in this said village about 37 years ago. Post of it is further stated that due to river erosion, the petitioners, the petitioner's parents shifted from village Banchadoba to village Pani, Panikramrar. Their names were entered in the voter list of 1977. They said village. Most of the petitioner also claims that after her marriage with Porosh, Porosh Ali, her name is recorded in the voter list of 1977 along with her husband in village, let's say, Panikramrar under PS Lokipur in the district of Gwalpara. And she does not know why, inverted commas, T, bracket close, mark is there against her without any cause. And she also relies on a linkage certificate issued by the secretary of Tarangapur, Tarangapur, Gaon Panchayat. which is countersigned by the BDO of Jaleshwar, JALESWR Development Block. Full stop. In support of our evidence, the petitioner has exhibited 3 documents, being certified copy of NRC 1951 within bracket Exhibit A, certified copy of voter list of 1966 within bracket Exhibit B, and original copy of original linkage copy within bracket Exhibit C. Full stop. Be it mentioned that along with the evidence on affidavit, the petitioner has enclosed the following documents as unexecuted documents as not as being extract copy of voter list of 1970 within bracket Annexure 1, extract copy of voter list of 1985 within bracket Annexure 2, extract copy of voter list of 1989 within bracket Annexure 3, extract copy of voter list of 1997 within bracket Annexure 4, extract copy of voter list of 1997 within bracket Exhibit 5, Annexure 5. Full stop. Next para. Inner cross-examination, DW1, amongst others, has stated that her mother gave birth to 1 son and 3 daughters, they are give a dash Abdul 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 Malik MALEK, herself Sakiron Nessa SAKIRON Nessa, and Sanifa 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 Khatun. And she also claims that after 1997, she was casting vote till date. And that she was marked with letter inverted commas D in 1997. And she has been issued a electoral photo identity card by the Election Commission of India. Next paragraph. In his evidence on affidavit, the DW2 has only stated that he is a citizen of India by birth, having permanent residence of the locality mentioned in the said affidavit. He also claims to be the father of the petitioner, and that her name and that his name is recorded in the NRC of 1951, 1985, 1989, and 1997, which has been submitted with the evidence of DW1. So in his cross-examination, the DW2 has stated that his grandmother gave birth to one son and it was her father left 2 sons and 1 daughter. They are Sabu Sheikh, SABU, Sabu Sheikh, SK is Sheikh, Jorina Khatun, JARINA Khatun, and Sofizuddin, SOFIZUDDIN. He also states that he has 1 son and 3 daughters who are Abdul Malik, Fulmati Nessa, Sakiron Nessa, and Sarifa Khatun. Next para. Next para. On an appreciation of the documentary evidence, although we find that the NRC of 1951, which was exhibited as Exhibit A, is not admissible in evidence on the ground that the said document is a certified true copy of the NRC of 1951 issued by the Inspector of Police within bracket border, but the said authority did not exhibit the original document. Full stop. The said certified true copy of the NRC cannot partake the character of a certified copy, which is not issued in accordance with the requirement of Section 76 of the Evidence Act, read with Section 77 of the said Act. Full stop. Accordingly, the presumption as to genuineness of certified copies cannot be drawn as per the requirement of Section 79 of the Evidence Act. Full stop. Nonetheless, in the said NRC, the first entry is of Putu Sheikh, Putu Sheikh, with father's name shown as Binod Sheikh. Was in the written statement, the petitioner has stated that her grandfather's name is Putu Bujuruk Ali, Putu Bujuruk, Bujuruk Ali, son of Bigot Ali, Bigot, Bigot Ali. Which does not match with the entries and in entry number 1 of the said NRC of 1951. full stop. Although the petitioner has made an attempt to show from the electoral roll of 1966 within bracket exhibit B that Puttu Bujuruk Ali, son of late Bigot, Bigot, is her grandfather. But there is no voter list of the projected father and the grandfather together in any of the electoral rolls. Exhibited electoral rolls. Full stop. In her proceedings, next part, in her proceedings under the Foreigners Act, read with the Foreigners Tribunals Order, 1964, the petition is required to show that she's a daughter of legitimate Indian citizens whose continued were ordinary citizens of India from first day of 1966 as envisaged under section 6 dash capital A within bracket 2 of the Citizenship Act, 1955. Therefore, the entries made in the electoral roll of 1966 is not sufficient to link the petitioner to projected parents for the purpose of showing that the parents of the petitioner were ordinary residents of India after 1/1/1966, as per the requirement of section 6A capital 6 capital A within bracket 2 of the Citizenship Act 1955. Therefore, a mere statement by the petitioner of referring the name of a projected grandfather with connecting the name of the father of the petitioner with certain aliases would not substitute as a proof that Puttu Sheikh, projected to be the grandfather of the petitioner, was the same person as Puttu Bujuruk Sheikh
Ali.
or Puttu Bujuruk Ali, whose name appears in the electoral roll of 1966. Next paragraph. Insofar as the link certificate is concerned, which is marked as Exhibit C, is not found to be an admissible evidence because of the fact that the said Gaon Panchayat certificate contains the state emblem of the Ashok pillar of pillar of Ashoka at Sarnath. Oh, no, it's what is it called? What is it called? Land. What is the name of the emblem called? Land.
Lordship, state emblem,
No, what is the name of the state emblem?
oh, Ashok Stamba,
Because there's a particular name. Give this,
Land capital.
land.
Land capital.
Land capital of Ashoka. ASOK. Right.
Capital.
Full stop. Either as it may, even the entries made in the said Gram Panchayat Secretary's certificate would only show that the petitioner, whose husband is Porosh, P-O-R-O-S-H, Ali, had shifted from the said Gaon Panchayat area by virtue of a marriage. And according to the said certificate, would not be sufficient to prove the parentage of the petitioner or to link the petitioner to someone who is a bona fide Indian citizen. Was an ordinary resident in the country as per the prescription of Section 6, capital A, within bracket 2 of the Citizenship Act. Next paragraph. It may also be mentioned that under the Representation of the People Act, 1951, the election officer has the power for extensive revision of the electoral rule and the verification of the names contained therein. And it is in the said context that the electoral registration officer had called for a local verification in respect of the petitioner, for which the electoral registration officer, local verification officer conducted a verification and its report was submitted to the electoral registration officer, 39 Jaleshwar LAC. Dated Thank you. And accordingly, the electoral registration officer submitted a format for reference. The competent authority, and accordingly, the Superintendent of Police Border made the reference before the learned tribunal. In this regard, it has been mentioned in paragraph 1 of the impugned opinion that on an order from the Election Commission of India, intensive revision of draft electoral roll was to be published based on door-to-door enumeration, taking 1/1/1997 to be the qualifying date. And the ERO detected that the name of the petitioner was entered in the draft electoral roll, having no base on 1/1/1997. And accordingly, the ERO, having doubt of the nationality or citizenship of the petitioner, called for a verification report, leading to the reference by the Superintendent of Police Border Goalpara. Next one. In view of above, and in the absence of any electoral roll of electoral roll containing the name of the petitioner after 1997, no presumption can be drawn that the petitioner was a valid voter in the year 1997, that she had casted her vote thereafter, which is not which is as claimed by the petitioner in a evidence on affidavit. No, sir, as stated in a cross-examination. Next, in view of above, the court does not find any infirmity with the opinion expressed by the learned tribunal. Most of the documentary evidence exhibited by the petitioner does not connect her to her prosecuted parents or grandparents, or that the petitioner, petitioner claimed to be a citizen, and that the claim of the petitioner of being a citizen of India, or claiming through her parents and prosecuted grandparents, fail, as the petitioner has failed to prove that either her parents or her grandparents were ordinary residents of the country, as envisaged under section 6 A within bracket 2 of the Citizenship Act, 1955. Accordingly, this writ petition stands dismissed. Next, the learned counsel for the petitioner had stated that the matter be remanded back to the learned tribunal for a fresh opinion by giving an opportunity to the petitioner to submit additional written statement as well as additional affidavit. The said prayer cannot be considered to, because in exercise of jurisdiction, so certiorari jurisdiction, court can only examine the correctness of the decision or decision-making process of the learned tribunal. In the absence of any positive statement by the petitioner that the written statement or the evidence on affidavit by the DW1 and DW2 lacked appropriate pleadings or lacked in the material particulars, it is not for the court to substitute its view and to issue a direction to the petitioner to file a additional written statement or additional evidence, which is not a basic prayer before this tribunal and before this court. First of all, according to the said prayer can also not be considered by this court. According to the writ stands dismissed, let the records be returned back. Along with the true copy of this order for making it a part of record by the learned tribunal. Next, the consequences of the opinion shall follow. Next para, the interim bail that the bail granted by order dated 7/2/2017 stands recalled and vacated. Get full stop. According to the matter stands adjourned. List after 2 weeks on a date to be fixed by the registry.
Item 6 for hearing.
The contested case, my lord, for the
Which page is the opinion?
opinion page 17, my lord. That's from
17.
17.
Where is your written statement?
Written statement, my lord, that is
Is a common written statement or a separate written statement?
separate. What would be annexure A, page 12, my lord.
Okay. In respect of this Dasarath Das,
Yes, my lord.
is there any voter list of the person along with his projected parents?
Yes, my lord. That is 70 additional affidavit, my lord, filed by me, my lord. That was filed 10/4/19. Here I have annexed here affidavit in evidence along with the papers also, my lord.
Okay.
In the voter list of 75 it is there, my lord.
No, 75 is not an exhibited document.
Yes, voter list is
Exhibited documents are 70, 85, 97, 2009 and 16.
but here it is 75, it is mentioned affidavit evidence in sheet DW1. It is mentioned 75 voter list.
DW1.
Yes, my lord.
Just a minute.
That my parents voter list enlisted voter list 70, 75. My name has been enlisted in the voter list of 1975, 55, 97, 2009, 16. DW2, my lord, or DW1 is also in case number 3350. My wife's case. My lord.
No, no, it is not there. 75 voters is not an exhibited document.
But in the, that in the DW, that is my lord, one, it is there, my lord. I have annexed here, but that was not exhibited possibly. my lord. I have annexed here.
That
along
is
with
annexure, sorry, exhibit number?
Exhibit 70, page 70 voter list, 75 voter list. Yes, my lord. Yet, as it was not certified copy, possibly it was not, my lord. But I have annexed here, my lord. Annexed are,
No, no.
it's page 13.
No, no, that was, if you can say it in a lighter note that what you have done is brilliant, but it can't be accepted.
Yes.
It must be an exhibited document for us to look into it.
But judgment, it is mentioned on this.
You just look at this. We'll send you the exhibited documents.
Oh, it is my lord mentioned in the judgment, bottom, page 23. From the above facts as disclosed by exhibits, it is found that respondent who those submitted exhibit A revenue receipt, but failed to prove that the name mentioned in exhibit A is his father. On the other hand, extract copy of the voter list 1975 shows enrollment of the respondent Dasarath's name along with his father, which gives rise to the fact that Dasarath Das was for Alipara Part 2 in the year 1975 to decide the allegation. Page 23, bottom, my lord. From the above facts, but no documents were there prior to 66, it is mentioned. To decide the allegation base here is taken as 66 or prior to that, but the respondent failed to submit any convincing document to show that his father, grandfather resides at Poralipara Part 2 prior to 1966. And link certificate failed by the petitioner number 2, but that link
In respect of land documents, there is no evidence on affidavit, no statement.
Oh. The WS is also very short, my lord.
It's good to save money. Less ink,
And
less
links-
paper.
Link certificate where she is presently staying, she has submitted, but where from she has come, that was not submitted. Subsequently, she has given me that certificate that my father's name is there in that area, and that is the certificate, my lord. That was not link certificate was produced before the honorable court, my lord.
Well, then you failed everywhere.
Yes, my lord. In spite of she has did all relevant documents.
And for the lady, does she have any voter list along with her parents? No.
No, my lord. Prior to her marriage, my lord, she did not cast any votes, my lord. After marriage, it was marriage was, my lord, as by my instruction in the year 1980.
In
Well-
the year 1980.
Yes, my lord.
What is the first voter list?
Voter list, my lord, as she has, my lord, filed her affidavit in opposition and evidence in sheep, my lord. That is page, my lord. I have annexed here, page 14. She has cast first vote in the year 1985, page 15.
85 is the first voter list.
Voter list. Lengthy Singha, my lord. Thereafter, she fled through, my lord. Horalipara, 97, 16, etc. Prior to her marriage, she never did not cast any vote.
Any other document for the lady to prove her connection with her projected parents?
Projected finance, my lord. That was, my lord, one link certificate was, my lord, placed before the planet code below, my lord.
Which page?
No, no. Additional.
See.
Where she was married, that in that area, my that certificate is there, madam. Possibly it was. Better ask it. Did you? Biswajit Das son, he was GW2.
Uh, Ms. Sharma, can you get us information if the central government appoints a leader in the tribunals? Are you aware of it? No.
No, I will ask the SGI lordship.
Not appointed.
Huh?
Generally, APP, AGP was. Revised. Yes, lordship. AGP conducting the case, lordship. AGP is conducting.
We can't jump to a conclusion. In this case, which page is the opinion? Page 17. Please look at page 17. S. Hussain, Assistant GP for the Union.
No.
What a statement.
Because why it was written lordship maybe because power has been delegated to state government lordship.
Assistant government leader.
So
No, it may be regulated by, delegated to anyone or regulated by anyone. But the question is that who represented whom?
GP is my father is holding the post of GP at present, my lord. How can it be, my lord, union? He is representing the state only.
active.
Huh?
No, we don't know.
No.
Normally, we will presume the order to be correct.
Assistant GP may be there from the state, but not from this central.
State has appointed
We don't
lordship.
know. That's why we are asking question to Ms. Sharma. Please make an inquiry
Lordship, I will intimate at to lordship.
whether it's available or not. Because normally, the Union of India doesn't spend on lawyers in the district.
Yes.
But then, Mr. Das, there's nothing in this case. You not been able to connect anything.
So many mistakes are there, my lord. But here it is mentioned, my lord, is on, my lord, DW2 is in the paragraph 4. He has mentioned my mother is illiterate and illiterate person, for that which I have submitted here with a few voter list, the original and other requisite documents of my mother, which can prove that my mother is not a foreigner or illegal migrant as alleged in the notice and the same voter list. But here in the judgment, as it is evident, my lord, in the last findings, my lord, may I read the relevant portion, my lord? Paragraph, my lord, 12 and 13, my lord.
Yes.
Paragraph 12, it is mentioned, my lord, on examination of the exhibit so it is found that exhibit A is the land received in the name of the Gedaru Ramdas, which was issued on 30/12/65, exhibit A1. Copy of Kesa Patta in the name of Gedaru Ramdas, son of Bodon Chandra Das, which was issued 14/9/84 by the settlement officer Golpara Dhuguri. NRC details with a Xerox copy NRC is found illegible and also not exhibited, so NRC is liable to be discarded. Exhibit C is the certified copy of the voter list of 70 from the Horalipara Part 2, where name of the Gedaru Ram Das, son of Bodon Chandra Das, and Phelaivala, wife of Gedaru Ram, or enrolled in serial number so and so. Exhibit D is the certified copy of the voter list 85, Horalipara Part 2, where name of the Dasarat Das, son of the late Gedaru Ram Das, wife of Dasarat Das, were enrolled at serial number so and so. Is the certified copy of the voter list 97, Bolodmari, where the names of the Dasarat Das, son of Gedaru Ram Das, and Kusumbala Das, wife of Dasarat Das, were enrolled at serial number so and so. The extract copy of the voter list 1975 shows that enrollment of the name of the respondent parent
Gedaru Ram Das and Felaiwala along with respondent Doxorot Das at serial number so and so from the village Bhoralipara under Abhaipuri LSC. The extract copy of the 2009 shows enrollment of the name of the Dasarot Das and his Kusumbala wife Kusumbala Das from the voter list so and so. The extract copy of the voter list 16 shows enrollment of the name of the Dasarot Das and his wife Kusumbala Das at serial number so and so of the Gwalpara LSC. State failed to rebut above facts as disclosed by exhibit as well as evidence of Dasarot Das by cross-examining him. From the above facts as disclosed by exhibit, it is found that the respondent though submitted exhibit A revenue reception so and failed to prove their name mentioned in exhibit A is his father. On the other hand, exact copy of the voter list 75 shows enrollment in the respondent's Dasarot name along with his father, which give rise to the fact that Dasarot Das was Koralipara Part 2 in the year 1975. To decide the allegation base year is taken as 66 or prior to 60 but the respondent failed to submit any convincing document to show that his grandfather resided at Horalipara Part 2 prior to 1966. On examination of the exhibit of FT case number so, it is found that exhibit A is elector's photo identity card, which is issued in the name of Kusumbala Das, wife Dasarot Das, and her card number so, certified copy of the voter list 66, village Dhupuri, where name of the Konaram Das and son of Kulu Das and Dayamui Das, wife of so enrolled in so, is the certified copy of the voter 1970, village Dhupuri, where name of Konaram Das, son of Kulu Dayaram, wife of so, certified copy of voter list 1979, village Dhupuri, where name of Monoram, son of Pulu and Dayamui, wife of Konaram, were enrolled in serial number so. Certificate copy of the voter list 89, village Dhupuri, where name of Konaram, son of Pulu and Dayamui Das, wife of Konaram, were enrolled in serial number so, house number so. F is the link certificate issued by the circle officer, Bijni Revenue Circle, which reveals that Kusumbala Das is the daughter of Konaram Das and she was married to Dasarot Das, son of Gedaru Das. On careful scrutiny of Exhibit F, it is found that Exhibit F failed to make a link between respondent Kusumbala Das with her father Konaram, whose name was enrolled in the voter list of 66 at serial number 127, village Dhupuri. Rather, F is silent in showing enrollment of Kusumbala's father Konaram in the voter list 66, Exhibit B. So it creates doubt that Konaram Das, village Dhupuri, Exhibit B is the father of the respondent. To decide the allegation and illegal migrant is the base year is 66. So the link certificate what has been submitted by her where she was brought, she has come after marriage. But original areas certificate, my lord, I have placed, my lord. One chance may be given, she will, my lord, prove dear, my lord. And 75 total list also it is mentioned, my lord. Exemption.
Mr. Das, for you also there is same thing. There's no averment in the writ petition that your pleadings or evidence lacks in something. It's not for the court to find out and then say that you need further evidence or file a further written statement.
Documents were subsequently, some papers were given to me subsequently because a repetition was filed in the year 2017. After collecting all papers also, my lord, affidavit in C, etc., I filed in the year 2019 because there's belatedly they collected. Even this 2024 certificate, what has been given me in the year 2024, my lord, I have given submitted before your lordship. Because that was my lord certificate where she was after marriage, where she was she came dear, my lord, from his original place.
Okay, I understand, but this is not your case that the evidence of pleadings lacked something. In the writ petition, that's not the ground.
Yes, my lord.
Thank you, sir. Mr. Sharma?
Lordship. Humble submission is that there is no infirmity in the opinion, Lordship, was by the learned tribunal, and Lordship has pointed out if WS is totally inadequate, Lordship, totally fake, Lordship. What WS has been placed before the tribunal, Lordship, and Lordship, when what document now?
He's a rickshaw puller, 70 years.
It is.
Proceeding starts from the year 2002, my lord, or 2000, my lord, 2. IMDT case initially it was, paragraph 2.
What document now he has placed lordship? Those documents are not admissible in evidence, lordship, because of pillar of Osoko was embossed at the top of the certificate, lordship. And lordship, apart from that, in advance, his lordship, this court has already decided, lordship.
That's
1970 of the Dasrat Das is of his father. 1970. And 85 is his own.
on.
In 85, what is the age of the proceeding? 85 voter list of Dasrat Das. What is his age?
Fifty-five. 35.
So therefore, he will be born in 1950.
Hmm.
He'll be born in 1950, and then the next voter list would be of 1971. 71, he was eligible to vote.
Yes.
So from 71 to
75 it was. 75 his name was reflected.
71 is not an exhibited document.
Not exhibited, but he, according to his statement, my lord, it was starts from 75.
In fact, in the before the tribunal, the case was badly conducted, but it appears that the tribunal it allowed the it accepted the exhibit. You know, on what basis? Only on the basis of Firisti. Firisti, you understand, documents are filed by way of Firisti.
Yes, ma'am.
So in Firisti, they mark there's a marking of exhibit ABC. This is how it's taken. This is the Firisti. Here, A, B, C, D, E is written. That is accepted by the tribunal. But this, in Guwahati, we can understand. Somebody saying that he is not practicing in the High Court, or practicing in the High Court does not go to trial court. But in Gwalpara, there is no High Court. You have to practice in trial court only. The lawyer has no experience in trial. Okay. We are reserving for orders. The submissions of Mr. H. Das, counsel for the petitioner. Name of the respondents will be given to you. So it's is concluded. Order reserved.
Hello.
What is the name of your father? I forgot.
Prakash Chandra Das.
Prakash Chandra Das.
Gwalpara district.
There's one. There was Keshav Chandra Das.
No, Keshav Nath, one.
Not Nath, Das. He's a senior, very sufficiently senior person. He's no longer alive.
No longer alive. Keshav Nath, he was Keshav Nath.
No, not Nath, Das.
My father is more than 50 years there, my lord, in now holding the post of GP
Okay.
without any AGP also.
Lordship, I have asked Mr. Architect Chaudhary, only High Court and CAT is represented by pleaders for union.
We
In
understand.
others, there is no pleader for union.
Thank you.
I crave your lordship's indulgence to make a mention at this hour, my lord. This is with regard to people who picked up, my lord, on 26th night, my lord. They filed a petition, my lord. My lord, can we move tomorrow, my lord?
Okay.
Deep privilege, lordship.
Today I was lordship, hoping that I would start at 2. So my wish got answered.
Perhaps 15 minutes here and there is still right on time.
It is right on time, lordship. So because lordship, I'm hoping I'll finish one legal proposition today. Ultimately, lordship, I have to assist the court with my arguments sounded on law. So yesterday I had only used it as an introduction to give you the basic facts, no more. Today I'm going to start building my arguments on law. So lordship, broadly, in my understanding and subject to, of course, correction by my learned friends on the other side.
You'll be referring to which matter?
Lordship, I'm going to refer primarily to Kunal Das, Pallavi. Today is mostly only one Kavita Das. I will show something specific.
Okay.
We've taken those files out.
Okay.
I'm today going to give a compilation to Lordship and we will start the law. Today will also give you a sense of Lordship how my plan is to deal with the propositions to cement my arguments. And somewhere down the line, I will come to distinguishing their judgments. Lordship, as I was saying, as I have understood their core arguments to be in the following 5 broad heads. Broadly, Lordship, firstly, one argument that has been professed is that irrespective of the fact that they are probationers, irrespective of that fact that they are probationers or not, some sort of inquiry needs to be held with respect to segregating or identifying the tainted and the non-tainted. So the argument essentially, some sort of inquiry is needed. They've referred to several judgments. They talk about a high court committee or something.
No, their argument is that there were 2 preliminary inquiries based on which this satisfaction was arrived at. So once there is an inquiry, their participation is a must, and therefore the inquiry also departmentally.
Right, I'm coming. In fact, Lordship, I'll give 5 of them propositions. They'll all get covered. But some sort of, they have also used that argument of an inquiry on the segregation of the tainted and the tainted. Because Lordship, this argument has a corollary. The corollary is that there can be no reliance on the police investigation or report. That is the corollary. So that's why I'm putting it as 2 arguments, which is not a substitute to this inquiry. That is the crux of the argument on the inquiry file. Then, Lordship, this is a further nuanced separate argument, Lordship, and I use the word nuanced because what they say is that the police report cannot form basis for the foundational facts as contemplated in para 40 and 41 of the Inderpreet Singh Kehlot judgment. It's been argued in detail that it cannot form the basis for the foundational facts. And I'm using these words because those are the critical words, Lordship. There is a subset to this argument. So if I say this is 3, that was 3A, 3B. The subset to this argument is, Lordship, the police report forms the foundation, not the motive. And thereby, the instant discharge is stigmatic. That argument goes further to say that the language of the order need not be seen, intent may be seen, but broadly they say it forms the foundation, not the motive, hence it is stigmatic. So this lordship goes to the argument of 311, Article 311 and the applicability to even probationers. That is the broad area of the argument. So on this argument, lordship, consequently the next argument comes that once the police report becomes the foundation and not the motive behind the discharge orders, then the Article 311 becomes applicable, requiring issuance of a show cause notice and hence the satisfaction of principles of natural justice. So this is how the broad argument goes in terms of building it. And finally, lordship, there is the argument of deemed confirmation. And in the case of the APS officers, because lordship had also asked that and I said I will answer, there is a reliance on the OM of 2004. There is a reliance on a transfer on an order, and then there is 38th August 2004 lordship, that OM, which the argument is that that amounts to confirmation in service. So these are the big major arguments. There are some smaller arguments also, but broadly this covers the major spectrum of the arguments of the appellant. Now, lordship, in response, what do I have to attempt to place before lordship and ladyship? And the first leg of my argument will be that all the appellants are probationers. There is no confirmation or deemed confirmation in any one of the case. Or rather, in every case, they are only probationers and probationers alone. Second leg of this argument, lordship, because today I will aim to complete this argument on probationers completely. There cannot be any concept of vested right to confirmation. Because lordship, this has been specifically used by one of my learned friends. There cannot be any concept of vested right for confirmation, lordship, or to confirmation, because as per the applicable rules, and they are statutory rules, lordship, confirmation is possible only upon satisfaction by the appointing authority. And lordship, this is a positive confirmation, not an implied confirmation. That's very important, lordship. Yes. And lordship, this has to be an expression, a communication that a confirmation cannot be deemed implied in any way. The statutory rules provide for it. And the law is settled. I'll be coming on that. 3, lordship. Then there is the case of the APS officers. So I'm using that as a subclass within the appellants. And their reliance on the OM dated 30th August 2004. And what I will establish, lordship, and hopefully show lordship that that is the law and how that OM will not apply, is that they are incorrectly placing reliance on that OM, the transfer order, and it does not amount to confirmation in service. This is the, if I may call it, the entire universe of today's argument. So what I will do now, lordship, I'm sharing a compilation. We will share a copy across also, lordship. No, yes, I know, I'll take it from my iPad. Everything's in the iPad. I need this at the end. So, lordship, this compilation, what I will begin with, I have placed here, lordship, all the service rules of the different departments. And I will then show the judgments. So what I'll begin with, lordship, is of course the probation rules, and then I will go on to the judgments in this compilation. You all can share. So if lordship and ladyship would be pleased to see, this is got lordship a total of 6 judgments and the relevant rules, lordship. Lordship may also just come to the index for a minute, Lordship. The proposition is, if applicable rules provide for extension of probation, no person can claim deemed confirmation in service unless a specific order of confirmation is passed by a specific authority. And Lordship may just broadly, if I may point out that Lordship, the first one is a constitution bench judgment, Lordship. Then there is a 3-judge bench, Lordship. Then there are very interesting cases, Lordship, with regard to judicial officers and judges also, whose termination of services took place during the probation period. And Lordship, the last one is the latest in that line of 2021, which is at serial number 7. Lordship, that's Rajasthan High Court versus Ved Priya, which is 3-judge. And Lordship, that is Justice Bobde, Justice Gawai, and Justice Suryakant. Brief judgment, but it broadly deals with what is the settled law. So Lordship may be very pleased to come to page 1 to 15 are the rules, Lordship. And I will just page by page just read the rules, Lordship, and request Lordship Ladyship to mark what will be the critical part in the rules with regard to probation and confirmation. Lordship may just note that all the complete set of rules are part of the affidavit. I yesterday showed the Kunal Das also compilation, Lordship. They are all in one place. So I have only for convenience put it along with this. So it's easy to refer in one document. So Lordship may just come to the first one being the Assam Civil Service Rules of 1998. And if Lordship may be pleased to come to the second page, which is Rule 22, Probation and Confirmation. Has Lordship got that? And Ladyship? May I read? Second page, Rule 22, Lordship. 22.1, a member of the civil service or a member of the service shall be placed according to seniority on probation for a period of 2 years, provided that the period of probation may for good and sufficient reasons be extended by the governor, being the appointing authority, in individual case for any specified period not exceeding a period of 2 years. So Lordship specifically 2 plus 2. Then Lordship, provided that the period of probation may be curtailed or dispensed with, not applicable here. Then 22.2, a member of the service placed on probation under sub-rule 1 shall, Lordship may mark, it's not may, it's shall, be confirmed against the permanent vacancy subject to the following conditions. Condition A being 2A, he has completed the period of probation to the satisfaction of the appointing authority. So it is clearly said the satisfaction of the appointing authority. And then Lordship B is the completion of the training and passing the departmental exam. So therefore, Lordship, and this is going to be reverberating in all the services except police, where the situation is a little different. So Lordship has marked that. May we proceed to the next page, Lordship, which is the police rules, Lordship. I am only putting the relevant pages, Lordship. First page and the relevant page. So Lordship may just note the short title is the Assam Police Rules of 1956. May come to the next page, Lordship. Part 4, Probation and Confirmation. Rule 15, Lordship, deals with probation. Now the police rules is a separate class of rules. That also is covered by the settled law. I'll show Lordship. Probation, all persons recruited to the service shall, except persons recruited under Rule 5.2, be on probation for a period of 2 years. So that is identical from the date of their appointment to the service. The period of probation for good and sufficient reason be extended by the governor in individual case by such period as deemed necessary. So Lordship, the difference here is the extension is open-ended. There is no period prescribed. This is the critical difference in the police rules as compared to the other rules. Everywhere it is a 2 plus 2, except police, where it's open-ended in terms of the extension. Now let us see, Lordship, in the police rules, the confirmation is also different. Rule 17, Lordship. Next page. 17.1. A person appointed to the service shall be confirmed in the service if A, he has completed his period of probation, if any, to the satisfaction of the governor. Now, this satisfaction cannot be implied or deemed. It has to be a positive act of a decision expressing satisfaction and its communication. B, Lordship, he has passed the departmental exams and successfully undergone the courses of training. And Lordship, and, which means all three, he is considered otherwise fit for confirmation by the governor. So Lordship may note that in the police service, the confirmation is 3 specific acts. Lordship may turn to the next page. Taxation, which is 1995, Lordship. May come to the following page, Lordship. And the next page where you have Rule 21. Now, Lordship, I am not going to read the full rule, but Lordship may mark 21(1) clearly says in the first paragraph that the probation is for a period of 2 years. And the second part of 21(1), which is the proviso, it makes it clear that it can be extended for any specified period not exceeding 2 years. So now taxation is also like ACS, 2 plus 2. And Lordship may come to 21(2)(a), which is on confirmation. He has completed the period of probation to the satisfaction of the appointing authority. So again, it's the same. Now, Lordship may come to the next one, which is the Lordship, the transport rules of 2003. And Lordship may again come to Rule 21(1), which deals with probation. Lordship may note it's identical. 21(1). Same Lordship, 2 years, extended for a period not exceeding 2 years. So maximum is 2 plus 2, 4 years. And again, Lordship may see 21(2)(a). The confirmation is he has completed the period of probation to the satisfaction of the appointing authority. Lordship may turn the page and note something different here, which is 22(3). I'm sorry, 21(3). If confirmation of a member is delayed on account of his failure to qualify for such confirmation, he will lose his position in order of seniority vis-a-vis such of his juniors as might be confirmed earlier than he. His seniority shall, however, be restored on his confirmation subsequently. So there's an interesting proviso here, or possibility, that if you don't clear it, you would for some period lose your seniority too. It's contemplated in the rules. Lordship may come to the next page, which is Lordship, the Labour Department. Lordship, Labour is 26 July 2007. Lordship may come to the third page, which is Rule 12, probation. Again, Lordship may note, shall be a probation for 2 years. And again, it says the proviso extendable not exceeding 2 years. 2 plus 2, 4 years. Next page, Lordship. Rule 14 is confirmation, Lordship. When a probationer has completed his period of probation to the satisfaction of the governor, he shall, only to the satisfaction of the governor, shall be confirmed in the cadre. And then Lordship may mark, similar to the police, there is an additional point here, 14(2). Point 1 is passing the departmental exam, but 2, he is considered otherwise fit for confirmation. So Lordship, just to make a note, Lordship, 2 departments, the letters of appointment, which I will refer to, Lordship, were temporary. This is the slight difference in the appellants, Lordship, that the appellants who are or who got employment in the taxation and transport department, Lordship, their appointment letters use the word temporary. And I'm going to show those, Lordship. And in the taxation, Lordship may mark the page, it's 381 of the writ appeal in Kunal Das. Kunal Das. Yesterday what we gave, I'll just read those two, Lordship. Mera wala khud. Marked hai? Mera wala hai, marked hai? Page number. Achha, okay. Lordship, it's very small. I will. 381 of Kunal Das, Lordship, the writ appeal is taxation. 128. सबसे मोटा कल वाला जो biggest. Actually, in fairness, as keepers of the paper, they have a lot of experience. It's not easy. Lordship, in our case, only there might be a few 50 files which are fairly thick. That's one case. Thank you. I'm only reading one.
But you will not appreciate that when we have to take this by way of trucks to our home and then sieve through the pages and then write an order.
Lordship, I will, in that support, point out something. I tell all my friends that we have to be grateful for those who are willing to move to the bench. We do 2, 3, 5, 6 cases on a good day, maybe 8, 10, versus 60 to 100. That is the number. I don't think any judge in any court has the luxury of doing less than 50, 60 matters. They are at least listed.
600 now.
My God. Yeah, I think Lordship is doing those foreign tribunal ones because I've had the occasion of listening. Those are
No,
also-
no. Average listing in the Allahabad High Court would be 600 per day. The average listing in Rajasthan would be about 500 a day. Patna, it would be about 300 a day.
Very difficult. Even if you read the first pages of it, it's 500 pages of reading. Not easy. And Lordship, we take the benefit of our colleagues then.
So
Yesterday,
now
Lordship,
you
there
are
was
on
a
the
case.
issue of recording of satisfaction.
Yes, Lordship.
Right now you are arguing on the issue of satisfaction. How do you record the satisfaction?
On that, I won't comment, Lordship. Yesterday, Lordship, there's a sad case that came on television on a complete thing. 104-year-old man was released after spending 48 years in jail. And 48 years in jail. And finally, he was released as innocent because everybody died. And even between Allahabad court sending the order of release, it took 20 days for him to come out of that also.
You see, there's a very difficult task. The task is that you see, in our court, we had a system where we issued rule and then the matter came for hearing. Now we do most of the hearing at the admission stage. And therefore, the files which are kept for hearing, they remain there. So, and you see, if we change the system, then it will be the bar who will start the protest that, well, you are doing something which is not congenial to the bar.
And
That's one part. The second part is that the seriatim, if we don't maintain the seriatim in hearing, then this happens. And then once we stick to that system, then out of turn hearing can be fixed for a few matters where we know that the accused is already there for 40 years, as you said, more than 40 years. We are unable to identify unless we create a robust system where we can track each and every file.
It's not easy.
And it's not easy for the judge to do it. So we depend on the registry. Again, the registry is overburdened.
It is overburdened. I had the occasion for studying this yesterday, Lordship. I went to the National Judicial Data Grid. Very interesting. On a particular month, I found that 23 lakh cases were disposed of. And 21 lakh cases have been added. So even while the disposal of 2 lakh cases has happened, it is just a fraction because the total cases are 5.5 crores. Lordship, page 381. I am, Lordship, showing an order of appointment of the taxation department. Once Lordship, Ladyship has it, then I'll read. 381 of the writ appeal.
The strength of the judicial officers, I think, so far as I remember, district-wise, Assam is the lowest numbers of judicial officers per district.
Per million or per district?
Per district. Because now you have lots of tribunals. You will have to have a POXO court, you have to have a NDPS court, you'll have to have this MSAT, you'll have to have those tribunals manned by judicial officers. Per capita, courts in Assam is less than the national average.
So the national average is somewhere around 20, 15 to 20. Law Commission's report has been taken to 50. Europe is 150 and USA is 220 per million.
So unless the state government, in fact, deliberates with this data.
Lordship, it's not easy
Yes.
because ultimately it's also part of the larger issue in terms of appointment. So I actually, I was again studying that data, Lordship, that the speed actually has increased in terms of appointments and number of appointments have increased. But the gap is so much, it's a lot.
378.
Lordship 381.
Yes.
So if I may read, Lordship, this is of August 26, 2015. And Lordship, I'll read this carefully because the language is interesting. On recommendation of the Assam Public Service Commission and subject to discharge without notice. Please mark that, Lordship. On recommendation of the Assam Public Service Commission and subject to discharge without notice and without assigning any reason thereof, the following persons are appointed temporarily as superintendent of taxes. And Lordship, this includes the writ appellants here. It's their order only. So this is, Lordship, in my humble submission, the most specific order in terms of a temporary / probationer, wherein it is also specifically mentioned that the discharge can be without assigning any reasons and it can be undertaken, Lordship, without notice. Now, Lordship, may come to the next page, 389, Lordship, which is the Transport Department, Lordship. Just two orders I'm showing because these are a little different where the words are used, temporary. 389, Lordship. Date is 15th October 2016. So I'm covering both the batches also, Lordship. And Lordship, both number 1 and number 2 are writ appellants here. They are in the appellants in the writ proceedings, 1 and 2. May I read the order, Lordship? The third line, Lordship, dated 30th June 2016. The following persons are appointed temporarily as District Transport Officer. That's the only point I'm making. Now, Lordship.
But under the Assam service rules, what do you call the temporary posts are also the almost like a permanent post. They don't have a separate category. The temporary posts are also accounted for in the Assam service discipline service rules.
So what I will, Lordship, now show through the settled law is that a probationer temporary. I'm using both the words simultaneously just so that I could show you that, and now I'm building on that. Lordship, if you are a probationer and if the law requires, or rather the statute requires, a specific act of confirmation, you are only a probationer. You can't read anything implied or deemed into that. That is what I'm now going to establish through the law. And Lordship, I'll now start referring to the judgments in my compilation. The first one, Lordship, is a constitution bench. Very old case. This one, Lordship, I'll have to read a little bit more in detail because the facts and the law are intertwined. So I don't have the choice of only going to the paragraphs on the law, Lordship. G. Ramaswamy versus Inspector General of Police, 1964, 6 SCR 279. Lordship may come to para 2. Okay. And if Lordship, Ladyship have it, I'll start reading.
Yes.
The case before the High Court. Now, very interesting, Lordship. I'll just broadly give the conspectus of the case. These were all, Lordship, sub-inspectors. And then there takes the state reorganization, Lordship. At that time, all these different states came out. Mysore became a new state, Lordship. And these sub-inspectors got transferred to the state. In the period, they were ad hoc made circle inspectors, which is the promotion post. Now, in this entire exercise, people who were on leave and others, when they came back, the circle inspectors, these people were reverted back to the sub-inspector post. So they filed a writ. And these proceedings have to deal, therefore, with the probationer or a temporary or an ad hoc appointment. So, Lordship, para 2. The case before the High Court was briefly this. All the petitioners were appointed sub-inspectors in the former Hyderabad state under Section 6 of the Hyderabad District Police Act, under Rule 399 of the Hyderabad District Police Manual, issued by the Government of Hyderabad under Section 10 of the Hyderabad District Police Act. Posts of circle inspectors were to be filled by promotion from the rank of sub-inspectors. Now, Lordship may go 9 lines down, and on the right-hand side, it starts the case of the petitioners in the High Court. I'm only in the interest of time, Lordship, keeping it as focused as possible. The case of the petitioners in the High Court was that their names were included in the eligibility list published in the month of October 1956 before the States Reorganization Act came into force on November 1, 1956. And what do they say? They therefore contended that in view of the entry of their names in the eligibility list, they were entitled as a right to promotion to the post of circle inspector as and when vacancies occurred. On the coming into force of the States Reorganization Act, certain areas from the states of Bombay, Hyderabad, Madras, and the whole of Coorg were made part of the new state of Mysore in addition to the existing state of Mysore. Now, Lordship. So, Lordship, why this becomes important is because an argument has also come that my name is in this transfer order, my name is in this completion, my name is in this gradation list. So, I am building this while this is on the promotion. The law in terms of probationers or temporary will get settled here. And these arguments get addressed through this judgment. Para 4. The petitioners continue to serve in the new state and as they were in the eligibility list referred to above, they were promoted as circle inspectors on various dates. So these are people promoted. Lordship, say last line, second last line it starts. It also appears that pending integration, promotions were made from these eligibility lists ad hoc or as, turning the page, Lordship, they were called out of seniority and continued to be so made pending integration. The petitioners were thus promoted ad hoc circle inspectors from the eligibility list received from the former Hyderabad state and continued to act for varying periods as such. Pause for a minute, Lordship. I would personally say, Lordship, that these are people at a much higher pedestal. Because these are people in service, they have ad hoc been promoted. Continuing further. It appears further that the petitioners were ordered to be reverted when certain confirmed circle inspectors who were on leave or on deputation outside the state returned to the new state. Thereupon, the petitioners filed writs before the High Court in which they claimed that they had been put in the eligibility list by the former Hyderabad state. They were entitled as a right to promotion as circle inspectors and to continue as such thereafter. An order of their reversion amounted to reduction in line. So they've therefore prayed for a writ, order or direction, quashing the orders dated September 6, 1962, ordering their reversion and directing the state government to continue them as circle inspectors and confirm them as such. Para 5. The case of the state government was briefly, then I'm going to request Lordship to go 12 sentences below. And Lordship, the sentence which starts with February 1958 after that. 12 sentences. Lordship with me? Para 5. Unless Lordship is faster in going ahead.
Yes.
In 1962, when senior circle inspectors returned to the state from deputation, some officiating circle inspectors other than the petitioners were reverted. This is what the state pointed out. They filed writ petitions before the High Court in 1962 contending that even though they had been promoted later, they should not have been reverted in view of those junior to them in the provisional list should have been reverted. This contention was accepted by the High Court and in consequence reversions began to be made in accordance with the provisional list in compliance with the view taken by the High Court. And Lordship, it's important. That was why the junior most sub-inspectors according to the provisional list who were in the eligibility list and who were officiating as circle inspectors were reverted. In consequence, the petitioners have also been reverted when senior officers came back to the state. It was further urged that the eligibility lists, please mark Lordship, gave no right to the sub-inspectors whose names were borne on those lists to promotion as circle inspectors, though it was not disputed that only those who were in the eligibility list could be promoted as circle inspectors. But the fact that a sub-inspector's name was in the eligibility list, please mark, did not confer any right on him to promotion in view of the rules. This is the argument of the state. Further, it was contended that the officiating circle inspectors could not claim confirmation as an automatic right. So now the confirmation angle is coming. As an automatic right after they had worked for a certain number of years as such, and that they could only become confirmed circle inspectors when orders to that effect were expressly made by the government. So applicability of rules, Lordship, is urged, and also that an order of confirmation is required. In the present case, the petitioners were never expressly made by the government. In the present case, the petitioners were never confirmed by the government as inspectors. There were therefore no question of any reduction in rank. It is not in dispute that the petitioners were not reverted on account of any fault on their part. They had to be reverted only because of the exigencies of service, as senior inspectors had come back to the state from deputation or had returned after leave. It was urged that the reversion in the present case could not amount to reduction in rank and was in the ordinary course due to exigencies of service. Turn the page to para 7, Lordship. This is where the law will get discussed. The first two questions that fall for consideration are whether the fact that a sub-inspector's name is put on the eligibility list gives an indefeasible right to him to promotion, and whether after such promotion on a temporary or officiating basis, he gets a right not to be reverted under any circumstances. We are of the opinion that the fact that a sub-inspector's name is in the eligibility list gives him no right of the kind urged on behalf of the petitioners. Pause, Lordship. This is what the Constitution bench clearly says. So if any argument is made that my name is on so-and-so list, grade list, transfer list, my name is on any list of completing the exams, that argument will not hold true. Even if your name is on that, if there is no confirmation, which is what this judgment will then establish, you cannot claim that, because that is not, the confirmation is not a indefeasible right. And being on the list does not create that indefeasible right. Lordship may then move 14 sentences below. In the middle of the page, Lordship, bottom middle of the page, there is a sentence that says, it follows therefore that the mere fact. It follows therefore that the mere fact that a sub-inspector's name is once put in the eligibility list does not give him an indefeasible right to promotion as a circle inspector. Then there is Rule 486, which governs promotion generally. It lays down that promotion cannot be claimed as a matter of right, though officers and men of all rank are entitled to expect promotion if they have good records and if they are smart and efficient and have a thorough knowledge of their duties. This again clearly shows that merely because a sub-inspector's name is put on the eligibility list, he cannot claim promotion as a matter of right. Rule 486, now Lordship may mark. Rule 486 further provides that all officers who are promoted will be on probation for a period of 2 years. They may be reverted at any time during this period by the authority competent to promote them if their conduct and work are not satisfactory or if they are found unsuitable for the appointment to which they have been promoted. This clearly shows what the court holds. This clearly shows that even where a sub-inspector has actually been promoted as circle inspector, he remains on probation for 2 years, and during the period he is likely to be reverted if his work and conduct are not found satisfactory. This again negatives the contention on behalf of the petitioners that they had an indefeasible right to promotion because their names had been put on the eligibility list and they could not be reverted after they had once started acting as circle inspectors. Please mark, Lordship. Lastly, Rule 486 provides that the promoted officers will be confirmed at the end of their probationary period if they have been given satisfaction. This clearly shows that it is only when the probationary period is over and the promoted officers has been given satisfaction during the whole period that he will be confirmed. It is clear, therefore, reading rules 401 and 486 together, that the mere fact that a sub-inspector's name is put in the eligibility list does not give him any indefeasible right to promotion. Further, the fact that he is actually promoted temporarily or as officiating does not give him any right to continuance even during the period of 2 years probation, and he is liable to be reverted at any time even during those 2 years if his work is found to be unsatisfactory. It is only when the authority concerned has found that his work and conduct are satisfactory during the probation period that he can be confirmed. The contention of the petitioners that they had any right under the eligibility list for promotion, or that after they had actually been promoted, they had a right to continue in the post of circle inspector, therefore must be negatived. Para 8. This is very important, Lordship, for us. It is further been urged on the basis of Rule 486 that the petitioners had worked for more than 2 years on probation. They had become automatically confirmed under the said rule, and reliance is placed on the following sentence in Rule 486, namely, promoted officers will be confirmed at the end of their probationary period if they have been given satisfaction. The law on the question has been settled by this court in Sukhbana Singh versus State of Punjab. It has been held that in that case that a probationer cannot, after the period of probationary period, automatically acquire the status of a permanent member of a service unless, of course, the rules under which he is appointed expressly provide for such a result. Therefore, even though a probationer may have continued to act in the post to which he is appointed on probation for more than the initial period of probation, he cannot become a permanent servant merely because of a flux of time, unless the rules of service which govern him specifically lay down that the probationer will be automatically confirmed after the initial period of probation is over. It is contended on behalf of the petitioners before us that the part of Rule 486, which we have just set out above, expressly provides for automatic confirmation after the period of probation is over. We are of the opinion that there is no force in that contention. It is true that the words used in the sentence set out above are not that the promoted officers will be eligible or qualified for promotion at the end of their probationary period, which are the words to be often found in the rules in such cases. Even so, though this part of Rule 486 says that the promoted officers will be confirmed at the end of their probationary period, it is qualified by the words if they have given satisfaction. Clearly, therefore, the rule does not contemplate automatic confirmation after the probationary period of 2 years. For a promoted officer can only be confirmed under this rule if he has been given satisfaction. This condition of giving satisfaction must be fulfilled before a promoted officer can be confirmed under the rules. And this condition obviously means that the authority competent to confirm him must pass an order to that effect that the probationary officer has given satisfaction and is therefore confirmed. The petitioners therefore cannot claim that they must be treated as confirmed circle inspectors simply because they have worked for more than 2 years on probation. They can only become confirmed circle officers if an order to that effect has been passed even under this rule by the competent authority. The first contention, therefore, that the petitioners before us have an indefeasible right to promotion once their name are put on the eligibility list, and that they are entitled to continue as circle inspectors thereafter if they have once been promoted on temporary or officiating basis, cannot be sustained. Now, Lordship, this is the judgment. Let us come base it, Lordship, on our facts. In each case, there is a 2+2 probation period. In police, Lordship, there is an extension. In every case, across the services, for all the appellants, there is a positive requirement of satisfaction by the appointing authority, being the Honorable Governor. So probation, even completion of that probation, in the absence of that recording of satisfaction and its communication, will not lead to any sort of confirmation of their service. in the absence of it. Now, Lordship, what does this Constitution bench? Broadly, it holds is that, Lordship, that if the rules provide for something, that alone will apply. Lordship, the old proposition of Nazir versus King Emperor, if something is to be done in a particular manner, it has to be done only in that manner and no other manner. The statutory rules here, Lordship, are specific. An order of confirmation is required. An order of satisfaction is required for them to be confirmed in service. I will deal with all the different scenarios, Lordship, through the subsequent judgments. There cannot be a vested right to confirmation. There cannot be an implied right to confirmation. And there certainly is no concept of deemed confirmation in any of the appellant's cases. They cannot claim a flux of time is going to lead to some sort of confirmation. नहीं पढ़ रहा मेरे बीच में बहुत है नहीं नहीं आपको तो देखना पड़ेगा मेरे उसमें है हो गया also do it. This was this judgment, Lordship. The next judgment, Lordship. This was, Lordship, a judgment of probation after promotion, officiating. Let's go to a case of termination, which, Lordship, is the next judgment of Pratap Singh versus Union Territory of Chandigarh. This is also, Lordship, a 3-judge bench, 1979, 4 SCC 263. 1979, 4 SCC 263. Very short, Lordship. The next 2-3 judgments are only 2 to 3 pages. Fazal Ali, Lordship, Justice Fazal Ali has written it, and I'll read the first para. This appeal by special leave is directed against the judgment of Punjab and Haryana High Court, dismissing the writ petition filed by the appellant against the order of termination. So this is, Lordship, to be marked. This is a termination order of a probationer passed by the Senior Superintendent of Police. The appellant was appointed on July 2nd, 1973. Please mark, Lordship, as a temporary assistant sub-inspector of police. On 26 September 1977, his services were terminated by the senior SSP. Against this order, the appellant moved the High Court of Punjab and Haryana, but his petition was rejected. Thereafter, he came to this court, and after obtaining special leave from this court, the appeal has been placed before us for hearing. The short point taken by the appellant in this appeal is that under Rule 12.81 of the Punjab Police Rules, the petitioner must be considered to be on probation for a period of 3 years. And as the appellant had crossed his period of 3 years, he must be deemed to have been confirmed, and therefore his services could not be terminated. In support of his submission, reliance is placed by the appellant on a division bench judgment of this court in the case of Superintendent of Police Ludhiana versus Dwarkadas, where Justice Singhal, speaking for the court, observed as follows. So if Rule 12.23 and 12.21 are read together, it will appear that the maximum period of probation in the case of a police officer of the rank of constable is 3 years. For the superintendent of police concerned has the power to discharge him, please mark lordship, within that period. It follows that the power of discharge cannot be exercised under Rule 12.21 after the expiry of the period of 3 years. Now, this is what lordship he is relying on. Now, let us see what the 3-judge bench in this case holds. It is true that the observations made by this court support the contention of the appellant to an extent, but in our opinion, the division bench decision was not correctly decided as it has not considered the 5-bench decision of this court in State of Punjab versus Dharam Singh, where, considering the number of cases, this court observed, this court has consistently held that when a first appointment or promotion is made on probation for a specific period and the employee is allowed to continue in the post after the expiry of the period without any or specific order of confirmation, he should be deemed to continue in his post as a probationer. He should be deemed to continue in his post as a probationer only in the absence of any indication to the contrary in the original order of appointment or promotion or the service rules. In such a case, an express order of confirmation is necessary to give the employee a substantive right to the post, and from the mere fact that he is allowed to continue in the post after the expiry of the specified period of probation, it is not possible to hold that he should be deemed to have been confirmed. The reason for this conclusion is that where on completion of the specified period of probation, the employee is allowed to continue in the post without an order of confirmation, the only possible view to take in the absence of anything to the contrary in the original order of appointment or promotion or the service rules is that the initial period of probation has been extended by necessary implication. I'm pausing for a minute, lordship. The 3-judge bench holds that if there is no concept of deemed promotion, if it's not in conflict with the rules, if you have continued beyond the maximum period, and if an order of confirmation is required satisfaction, which is applicable in our cases, you are deemed to be extended in probation, which means an argument cannot be taken that nobody communicated to me that my probation is being extended. That is the corollary also. That you are deemed, the legal fiction is taken to the point that this is an automatic extension of your probation, and there is no requirement, as this 3-judge bench says, of you to communicate that I'm extending your probation. Now, lordship, this is why.
But there's one of any question coming up.
Of course, lordship.
You see, if there was any intention to give it to the affected persons, you would have given it to it, because otherwise they are bringing RTI records to show that the authorities, even the gazetteers, they were never communicated their orders.
Lordship, I must say, on instruction, and this was also raised before the learned single judge. In broadly majority of the cases, an extension order does exist. It is there. It's part of the record, lordship. It's not as if it's not there. Second, lordship, I must point out, when it was said what was brought before the single judge, each one of the petitioners there, lordship, their individual files were brought before the Honorable Court. And lordship, that is contrary to the arguments of what people have said. The learned counsels have tend to point to say that the case files were not brought. No, lordship. I say it with a sense of responsibility. Every one of the petitioners' official file was brought before the court and placed it. The court perused it. They were kept before the court for several weeks. I am also told, lordship, and reminded that the charge sheets were also brought onto record by them only. So a lot, and it's recorded in the order, because that's the last part that I will come to in my arguments, is just to peruse through the order, lordship. So therefore, lordship, let me, what has flowed from the bench, lordship, and let me attempt to, lordship, answer that. That, lordship, One, just to rephrase between the two, the constitution bench and this 3-judge bench, is that there is no concept of confirmation with efflux of time. That is settled. The second, lordship, that the only deeming fiction, if at all, will come is that you are extended on probation. That is a without prejudice to the argument that in majority cases they were extended and that extension is part of the file. And 3, lordship, if there is a specific requirement of the appointing authority pointing out taking a decision on the satisfaction, that has to be done. There cannot be reliance on being on an eligibility list, being on any other list, or reliance on anything else. These are the 3 things that, and as we go ahead, lordship, in the next judgments, we will show, lordship, that the court has also taken the 3 scenarios. What happens if it's only 2 years? What happens if it's 2 + 2? What happens if it is open-ended, like in the case of the police, lordship, and a confirmation is required? So all those scenarios are going to get covered. So it's only 7 judgments which will cover this entire law related to probation, lordship. If I may read, lordship, para 4. In the instant case, the appellant was appointed purely on a temporary basis and not on probation, and therefore Rule 12.8, which deals with the officials who are appointed on probation, does not apply to this case at all. Now, lordship, this raises an argument, as I have shown in the case of the taxation officers. Their appointing letter, their appointment letter, specifically says that you are on a temporary basis, without notice, and without assigning any reason, you can be discharged. In the case of the other officers, the labor officers, lordship, transport officers, it is, lordship, the word temporary is used. This judgment is dealing also with a temporary case. It is well settled that a person is appointed on probation only if he is appointed against a substantive vacancy. In the instant case, it is not disputed that the appellant was appointed only against a temporary vacancy. Assuming, however, that Rule 12.8 of the Punjab Police Rule applies to the appellant's case and he is governed by 12.8, even after the probation of 3 years is over, the police officer shall not be deemed to be confirmed unless there is any rule which provides that in the absence of an order of confirmation at the end of the probation, the employee must be presumed to be confirmed. There is no such provision in the present rules, and lordship, I may point, there is no such provision in our rules across the service. In these circumstances, therefore, as held by this court in the case of Dharam Singh, which is a constitution bench, lordship, it must be held that if no express order of confirmation was passed after the appellant completed 3 years, it must be presumed that the probation was extended. And in view of that, lordship, matter, the appellant was a temporary and the services can be terminated at any time. So, lordship, the only interesting point is that even though he was temporary, by relying on the constitution bench, this 3-judge bench, lordship, makes a legal fiction for the settled law to say it will still not apply to him, even if he was a probation. I know it. वही तो बात कर रहा हूँ. That's the most important.
This Rule 12 is quoted anywhere? No.
No, Lordship.
You see, in the first part of the judgment,
Lordship.
it proceeds with the notion that it was a appointment to a temporary. The appellant was appointed as a temporary assistant.
Yes, Lordship.
Now, if you come to the last paragraph we were reading,
Yes, Lordship.
you were reading this paragraph 4.
Yes,
At
Lordship.
page 29, you see
Yes, Lordship.
third line.
Yes.
In the instant
Instant
case, it
case.
is not disputed that the appellant was appointed only against a temporary vacancy.
Yes, Lordship.
So vacancy and temporary posts are two different
Right, Lordship.
concepts.
And then the next sentence becomes critical. What the court does is, while it deals with him on the temporary basis, it places him on a higher pedestal, which is where the sentence becomes critical, assuming, however. So the court places him in that position also and says, then what the law would be.
No, because temporary vacancy is supposing what we understand, subject to correction, is that there's for example, my court master.
Yes.
The permanent post is permanently employed. He goes on 1 month leave. And then there's a temporary vacancy which has to be filled up. This is what the concept is.
It's correct. That is why, Lordship, this, and I will request if Lordship, we can just read those last 4 sentences again. He is clearly a temporary employee, not against a substantive post. Now what the court says. Assuming, however, that Rule 12.8 of the Punjab Police Rule applies to the appellant's case, and he is governed by Rule 12.8. So now it's saying that you are not on a temporary post, assuming you to be against a substantive post and the applicability of the rule. Even after the probation of 3 years is over, the police officer shall not be deemed to be confirmed unless there is any rule which provides that in the absence of an order of confirmation at the end of probation, the employee must be presumed to be confirmed. There is no such provision in the rules. Then applying Dharam Singh, it must be held. If there is no order of confirmation was passed after the appellant completed 3 years, it must be presumed that the probation was extended. So lordships in this case have taken an assumption of placing him as a probationer against a permanent post, and then said what is the settled law. It is the settled law that I am relying on, Lordship. Because my case also, Lordship, is similar. There is nothing in the rules across the services that enables them to claim confirmation at the end of their probation period. And this is what is being professed and argued. Our case is based squarely on G. Ramaswamy, on Pratap Lordship, and the following judgments, that you cannot claim confirmation if the rules provide for a specific act of satisfaction by the appointing authority. And the second, Lordship, is that the deeming fiction will actually be that you are continuing as a probationer, not as a confirmed employee. These are the two major points, Lordship. If I may assist Lordship on one point more, unless Lordship was about to say something and I spoke a little too much in haste. Lordship, I was just
reading this rule 12.8 of Punjab. It's a probationary appointment, extendable for 3 years, extendable by 1 year.
I haven't seen that, Lordship, and I'm grateful if Lordship saw it. I was just making 2 points, Lordship, that the first judgment of G. Ramaswamy is a constitution bench, which is also relying on Dharam Singh, which is a constitution bench. This 3-judge bench is relying on the principle laid down by Dharam Singh versus Punjab constitution bench, which is in the preceding paragraph. So the judgment is for the principle. And the second argument, Lordship, that flows is that the deeming fiction, what is being argued by the appellants is they are invoking the deeming fiction towards confirmation based on 2 things, a flux of time and then coming on to various different orders, transfer, posting, etc. What the court is holding is that the deeming friction is actually in their continuing or the extension of their probationing, not the confirmation. So actually, this judgment establishes that these 2 deeming fictions, when they are in front of each other, when the statutory rules require confirmation through satisfaction by the appointing authority, the deeming fiction will be that you are a probationer and extend it to be, which deals, Lordship, with my third leg, which I just earlier said, that in most cases there are orders of extension, but without prejudice. That is also not required because this court, the Honorable Supreme Court lays down the deeming fiction is towards extension of probation period. Actually, that is.
Someone is there. Plus one. Take motion. Take motion. Take motion. Some service goes. Also, temporary mentioning also by.
Detail that you are handling quite, I don't remember, but you are handling. And he said to trial court ka tha. I mean, in terms of finding arguments, they're very different. Very different courts, very different procedure. So, here that everybody, you're pending trial for president. Yeah. I didn't Pankaj I asked Pankaj to report. No, but I read your name. See that. How many cases are you? People. Seems. Oh. Enrollment in 2008. So that's all. So tell us. I was enrolled in 2010.
Yes.
So, Lordship, now I have dealt with two cases, Lordship. The third one deals with the discharge, Lordship, of a civil judge. Broadly, Lordship, two more arguments will come out, Lordship, through the balance judgments. That A, the purpose of probation gets enunciated in the various judgments that I'm showing. And the purpose of probation, Lordship, is after all efficiency and integrity of the administration. And that purpose, Lordship, as I read yesterday from Tulsiram Patel, Lordship, of the public office, public trust, public funds, is something that even the courts hold sacrosanct because, Lordship, it is in everyone's interest, whether it is an officer of the civil service and at any level, or it is within the judiciary, all appointments must be of a nature that they serve the public interest. And more importantly, Lordship, the posts have to inspire public confidence. That is how the trust comes. So, Lordship, the next judgment is two-judge bench, Lordship, 1996, 1 SEC 560, Satya Narayan Athya versus the High Court of Madhya Pradesh. And this is Lordship Justice Ramaswamy and Justice Hansaria. Lordship, may come to para 2. The petitioner was appointed on probation as a civil judge by proceedings dated 13/7/1979. On completion of the 6 months period, he was put on probation with effect from 16 to 80. Though 2 years period had expired. Now, Lordship, again, the same principle. A flux of time, probation is over. Though 2 periods period had expired, no order of confirmation was issued and he continued on probation. In view of the non-satisfactory nature of the service, the full court decided that he could not be confirmed. Accordingly, the orders were issued on 5/8/83, discharging him from the service under so-and-so rule of the MP Government Service Temporary Quasi-Permanent Service Rules 1960. When the petitioner filed a writ petition in the High Court, he was unsuccessful in the letters patent appeal, though he succeeded before the learned single judge. Thus, the petition has come before the Honorable Supreme Court. Para 3. The question, therefore, is whether the petitioner has been deemed to have been confirmed after his completion of 2 years of probation. Rule 24(1) of MP Judicial Service Classification, Recruitment and Condition of Services Rule 1955 provides every candidate appointed to the cadre shall undergo training for a period of 6 months before he is appointed on probation for a period of 2 years, which period may be extended for a further period not exceeding 2 years. Very similar to us. The probationers may, at the end of their period of their probation, be confirmed subject to their fitness for confirmation and to having passed by the highest standard all departmental examination. So again, Lordship, here is called fitness for confirmation. In our case, it's satisfaction. Para 4, next para, Lordship. A reading thereof would clearly indicate that every candidate appointed to the cadre shall undergo training initially for a period of 6 months before he is appointed on probation for a period of 2 years. On his completion of 2 years probation, it may be open to the High Court either to confirm or extend the probation. At the end of the probation period, if he is not confirmed on being found unfit, it may be extended for a further period not exceeding 2 years. It is seen that though there is no order of extension, this is very critical for me, Lordship. Though there is no order of extension, it must be deemed that he was continued on probation for an extended period of 2 years. On completion of 2 years, he must not be deemed to be confirmed automatically. There is no order of confirmation. Until the order is passed, he must be deemed to continue on probation. Now, Lordship, this is the law which is continuing through the decades. Para 5. Under these circumstances, the High Court was justified in discharging the petitioner from service during the period of his probation. Now, Lordship may mark the next sentence is very important. It is not necessary that there should be a charge and an inquiry on his conduct since the petitioner is only on probation. And during the period of probation, it would be open to the High Court to consider whether he is suitable for confirmation or should be discharged from service. So, Lordship, deeming fiction with the continuation, this judgment then specifically says, even if a letter of extension is not given, you are deemed to continue. And 3, Lordship, very importantly, no requirement of a charge or an inquiry. Which means, Lordship, I should be given an opportunity. I should be able to put out my point. Principles of natural justice should be complied with because you are a probationer. And that rejection, Lordship, is only because he is a probationer. And Lordship, the last point that comes out from this judgment is that the option is actually with the employer, not the employee. With regard to a probationer, the option is with the employer to discharge or retain. This is in a short judgment, all 3 principles come out. And this is all, Lordship, only qua probationers. May I continue to the next case, Lordship? The next case is interesting, Lordship. The next case, Lordship, eventually, the facts are against me. In those specific facts, the court gives him relief. And they are very, very different sort of facts. But on law, Lordship, this judgment, Wasim Beg, 2-judge Lordship, 1998, 3 SCC 321, Wasim Beg versus UP. Again, Lordship lays down the law and settles and reiterates what is the settled law. Dharam Singh, all of it is, Lordship, covered here. I'm starting with Lordship, may I take you to para 2?
Yes.
Basic facts. Yeah. The appellant was appointed as assistant manager in the respondent UP State Leather Development and Marketing Corporation in 1974, November 74. In 78, Lordship, the appellant was selected and appointed as divisional manager in the respondent corporation And then the letter of appointment of 1978 says his appointment will be on probation for a period of 1 year, which can be extended at the discretion of the managing director. His services are liable to be terminated on 1 month notice or salary in lieu of. He will be governed by the service rules of the corporation. Para 6, Lordship, 7 years later. Thereupon, an order dated March 1985 was issued terminating the services of the appellant. The order stated that the appellant was discharged from the service of the corporation with immediate effect, and that in lieu of 3 months' notice, he will be paid 3 months' pay. The pay for 3 months was deposited in the account of the appellant by the respondents. Para 8, Lordship, he filed a writ petition against the order of termination in Allahabad, Lordship. An interim order of stay was passed, Lordship, on the termination, Lordship. However, since he did not join, the High Court vacated that stay, Lordship, observing that the appellant would be entitled to full salary in case he succeeds. Writ petition eventually, Lordship, gets dismissed. Para 9, Lordship. High Court upheld the order of termination on the ground that the appellant was a probationer on the date of termination in 1985. These are the facts, Lordship. Lordship may straight away come to Para 15, Lordship. These are the 3 situations, Lordship. Whether an employee, and this is situation 1. Para 15 is situation 1, Para 16 is situation 2, and Para 17 is situation 3. This is the final law, Lordship. Whether an employee at the end of the probationary period automatically gets confirmed in the post, or whether an order of confirmation or a specific act on the part of the employer confirming the employee is necessary, will depend upon the provisions in the relevant service rules relating to probation and confirmation. There are broadly 2 sets of authorities of this court dealing with this question. In those cases where the rules provide for a maximum period of probation beyond which the probation cannot be extended, this court has held that at the end of the maximum probationary period, there will be a deemed confirmation of the employee unless rules provide to the contrary. Now, Lordship, so basically, if there is a maximum period provided, then deemed confirmation will come. But it depends on the service rules, Lordship. That is not dispensed with. Second situation. However, even when the rules prescribe a maximum period of probation, if there is a further provision in the rules for continuation of such probation beyond the maximum period, the courts have made an exception and said there will be no deemed confirmation in such cases, and the probation will be deemed to be extended. In this category of cases, we can place reliance on Shamsher Singh versus State of Punjab, which was a decision of the 7 judges, Lordship, where the principle of probation not going beyond the maximum period fixed was reiterated, but on the basis of the rules which were before the court said the probation was deemed to have been extended. So, Lordship, why I am pointing this out? Because Shamsher Singh has been relied upon by some of the appellates, Lordship. In Satya Narayan, which I just read, Lordship, although the rules prescribe that the probationary period should not exceed 2 years and an order of confirmation was also necessary, the termination order was issued within the extended period of probation. Hence, the termination was upheld. Now, situation 3, Lordship. The other line of cases deals with rules where there is no maximum period prescribed for probation. And either there is a rule providing for extension of probation, like the APS, Lordship, or there is a rule which requires a specific act on part of the employer, either by issuing an order of confirmation or any similar act, which would result in confirmation of the employee. In these cases, unless there is an order of confirmation, the period of probation would continue and there would be no deemed confirmation at the end of the probationary period. Lordship, APS, if you'll recall, is 2 plus an extended period without specific. Lordship, next page, below the judgments that have been quoted, in the recent case of Dayaram Dayal versus State of MP, to which one of us was a party, All these cases have been analyzed and it has been held that where the rules provide that the period of probation cannot be extended beyond the maximum period, there will be deemed confirmation at the end of the maximum probationary period unless there is anything to the contrary in the rules. In the present case, under the service rules in force at the time when the appellant was appointed on probation, there was no time limit on the period to which the probation can be extended. The appointing authority was required to issue a certificate of the appellant having satisfactorily completed the period of probation. This Lordship paragraph at the end of it finally holds in favor of the appellant. Because Lordship, there was a confirmation and it was after a period of 7-8 years. So his petition is allowed. Now, Lordship, if I may, respectfully, Lordship, urge a few submissions. Lordship, which is on law and the settled law. In all the appellant's cases, Lordship, including APS, under the rules, probation is for 2 years, extendable by 2 years, total 4 years. So, Lordship, all the services 2 + 2, excluding APS. In the case of APS, Lordship, under Rule 15(1), probation is 2 years plus extendable without any limit of the period. So if on probation, now Lordship, all the cases, whether of any service, there is a requirement of satisfaction by the appointing authority. These are the undisputed admitted facts, Lordship. Now, Lordship, let's look at the APS. Rule 15(1) of the APS rules has to be read with Rule 17, Lordship, which is the confirmation. And under Rule 17, Lordship, 3 conditions are required to be fulfilled. The first, Lordship, A, completion of the probation period and to the satisfaction of the governor. Then 17B, Lordship, passing the departmental exams and courses of training. And Lordship. So it's A plus B plus C. And he is otherwise considered fit for confirmation, Lordship. And Lordship, none of the appellants can produce a single order showing that they stand confirmed in service. What they are doing, Lordship, is respectfully, I would say, is clutching at straws. Trying to build arguments on the basis of posting orders, on the basis of passing departmental orders, increments, gradations. They rely on everything, Lordship. And in fairness, Lordship, that is their case. So they will urge whatever they feel could help them. But our case, Lordship, is...
There is also a notification by the governor.
I'm coming to that, Lordship. I will cover that specifically, the 2004 and its inapplicability. I am not running away from any argument, Lordship. And I am here to satisfy Lordship on each one of Lordship's queries. In fact, Lordship, that is why I'll say that is not and will not mitigate against the statutory rules which provide for a specific act of satisfaction. That's why I used that word, Lordship, clutching at straws.
But if we follow, I always have a query with regard to the applicability of common law in India. I always pose that question. But in this case, the common law is again the king can do no wrong. So once the order of the governor is there.
But not on satisfaction. That is my case. Of course, Lordship, we'll be coming just 2 more sentences, Lordship. I'll close this particular case with Lordship. I know it's time. Therefore, Lordship, what my last 2 arguments are on this is that the reliance on a posting order read with the OM of 2004, I'm taking it head on, Lordship, cannot mitigate against the statutory rules and particularly in the APS case of Rule 17. It cannot mitigate. Second, Lordship, therefore, in light of the settled law, even the APS officers are only probationers. My cases all are probationers / temporary. Then Lordship, and Lordship, all of them will be deemed to be continued on probation in the absence of a satisfaction by the governor or the appointing authority. Now, Lordship, I have 2 more judgments to rely on.
Take it up tomorrow.
Tomorrow? They'll take about 15 minutes only. They are short judgments on this proposition.
It is over. Oh, what is it?
So,
Arjun fellow generator. Arjun fellow generator.
मेरा कवर दे दो, पीछे बढ़ाओ। हाँ, वही। Lordship, when Lordship was referring, I'm making that assumption, you are referring to the 2004 notification of the governor. I'll be coming to that, 30th August.
Date I would forget, but there's a list where in the last paragraph it says the governor.
That's what, that is the one, 30th August, Lordship, 2004. Should I continue, Lordship? I'm not.
No.
You have another matter.
Secretary has to come to
I have.
take the dictation.
So when Lordship, your colleagues came, Lordship, and opened the door, then Lordship suddenly spoke to the court master and spoke. I thought maybe Lordship's bench is continuing, but our matter
There
is.
is a production list in this bench.
That's what he mentioned.
Because my esteemed sister also has a single bench.
I know every day at this time, I've noticed that Lordships get up and run around 3:30, 3:45, and then Ladyship has a bench.
This also shows that we work hard.
Lordship, English is a very nice language. I have had people who have tried to tell me, thoda hardly work karo, thoda hardly work karo. So it just changes the entire context, Lordship.
Just record the names. Mr. Das, Ms. Chaudhary. Just give the names.
Minus name.
Counsel for the appellants in so are present. No other appellants are represented. Actually, submissions of Mr. N. Kohli, Lal Senior Counsel, assisted by so and so. Take it from the last order. Remains inconclusive. List as a partner matter on. Make it tomorrow, 4/6/2025.
I'm grateful, Lordship, please. Grateful, Lordship.
Action list item 1. Hazrat Ali versus the Union of India and 5 others.
This is also allegation is same as my lord today's morning. That's item number 13. So I may be given time, my lord, I will get the instruction as well as the certified copy, if copy of the order is available in the tribunal.
Same order.
Same order.
Yes, Lord.
On Friday.
Here they were,
Friday, it is fixed on Friday.
here they were taken up when?
26,
Same day.
same day.
We have already passed an order in item number
13 man. Morning
13.
13.
Morning 13.
It will be same.
Case number is different.
But
Here,
case
Case number.
case number is there at page 9, Lordship.
FT case number.
here the,
FT case number is mentioned.
here the
In
ex
page
parte
9.
opinion date will change. Ex parte opinion dated 12/9/2017, passed by the learned member, Foreigners Tribunal number 5th, Kamrup Metro Guwahati, in
FT case number 348/2016.
in FT case number
348
348
2016. madam.
of 2016. Uh, Here,
Son of the.
in the earlier case, it was brother of the petitioner. Here it would be brother, the son of the petitioner, namely, Amir, AMIR, Amir Hamza, HAMJA, alias Amir Ali, has been detained. What is the time of the date and time of arrest is
The date.
26/5/2025 at about 4 a.m. In the earlier case, it was 2:30 a.m. Huh? That's the difference. That's all?
Yes, yes.
Okay.
Meanwhile, I'll get also the certified copies
Yes. The rest of it's same.
Yes.
Okay.
on Friday, not on
Friday.
deep.